Hello and very good evening to all of you. I hope I'm properly audible and visible to you. I hope you guys can see the screen as well. I would like to hear from you guys. If you can confirm in the chat box if I'm audible properly, and you can see if you can see my screen. If I'm audible properly, please confirm in the chat box. Thank you for confirming, guys. So we'll start this session in 2 minutes. We'll wait for others to join us. So today's session is going to be about the legal reasoning section and how do we deal with the complex passages in legal reasoning section. But before we delve into looking into the keys or looking into the areas which you need to focus while dealing with the complex legal passages, we'll have a general look. We'll have a look on the general things that you must keep in mind while solving the legal reasoning section. Right. So first, we'll start the session with a discussion on. We'll start the session with a general discussion on how to approach legal reasoning section, what is the nature of the section, and what does the CLAT expects. And then we will delve into some special tips and tricks in order to gain an edge over others in the legal reasoning section. Because anyway, it is one of the highest. It is one of those sections with the highest weightage, and apart from being the subject with the highest weightage, it is also a tiebreaker. So in case if two students score same marks, the legal reasoning score becomes the tiebreaker for deciding the rank, right? So if you have scored more in legal reasoning than others, than people who have scored an equal amount of marks in CLAT, then your rank would be better if you have scored if you have scored higher marks in legal reasoning. So that's why it's very important to get a better marks in legal reasoning section. And of course, if you look at the last 5 years paper, or in fact last 5-6 years of paper, you'd find that most of the time the legal reasoning section is one of the highest scoring section, right? So out of 32 questions that were asked in last year, and in fact last year as well, you actually went on to score 31 and 31.75 as well. Oh, so no, 30.75 and 31. So I think 31 was the highest last year. So it is actually one of the highest scoring section, and this is one of those sections. In fact, I usually say this, that English, legal, and logic, these are three heavy reading sections which ensures that you're going to NLU. If you do well in GK and quants, it ensures it decides which NLU you're going to. But your selection, whether you're going to NLU or not, it depends on English, legal, and logic, right? So, and especially logical legal reasoning, right? Because it is the highest scoring section. You can easily score 30, even more than that. Even more than 30 is possible. So possibilities are endless. You can actually go on to score 32 up to 32. But yes, a good score in legal reasoning section is somewhere around 28, 29. So if you're scoring 28 to 29, you are in top 98 or 99 percentile. I mean, at least your legal reasoning score is higher than at least 98% or 99% of the students who will be writing this test, right? So it's very important to score well in this section. So without wasting much time, we'll quickly go into the general tips and tricks to deal with the legal reasoning section. Now, first, it's very important to understand what exactly does CLAT expects us, especially in the legal reasoning section. The CLAT consortium, in their website, they have and in their brochure, they have clearly spelled out that you do not require any prior legal knowledge. In fact, if you deeply analyze, if you thoroughly analyze the past year papers, you'll understand that they have actually not asked a lot of questions based on legal, which are based on legal knowledge or which require any form of legal knowledge. Though I would not deny that there were some questions which required legal knowledge. Like for last year, there was a question. There were in fact two questions which required some form of legal knowledge, but very basic legal knowledge. One concerned with Article 21 and the other one with the age of majority. So that kind of knowledge may be required to solve one or two questions, but largely you do not require any knowledge. Clat is not testing your prior knowledge. See, legal knowledge is something that you'll get to learn in the law school. It's not something that you should learn before you go to law school. So be very sure that they are not testing you on your legal knowledge, but what they're testing you exactly is on your comprehension skills. Also, they want to test whether you are a good enough candidate to understand the legal reasoning legal principles, in fact, the basic legal principles, and are you able to apply them in the factual situations, right? So this is what they're testing you, and therefore don't worry, don't be concerned about whether you would how much law you should know. In fact, even if you do not know any law, you would still end up doing better in legal reasoning section, right? So there's no need of memorizing all those judgments. There's no need of memorizing the legal provisions. It's your comprehension skills that matters, right? And also, of course, your logical thinking ability, where you can apply the legal principles in the factual situations which are given in the questions. Right. Moving ahead. Now, what I'll do is I'll tell you a step-by-step process on how to deal with the legal reasoning section. How it is going to be a general description, the general step-by-step process on how do we approach the legal reasoning section, what kind of mistakes we can avoid, and what are the things that we need to focus on, right? Now, first and foremost thing, the first thing that you should keep in mind while dealing with the legal reasoning section is that you have to read the passage properly, right? You should treat the passage as the utmost knowledge that you have in law. So if the passage talks about murder, or let's say the passage talks about essentials of a contract, and they have listed out 5 essentials of a contract, but they have not listed, the passage does not list out, let's say, the age of majority as one of the essential conditions for a valid contract. Now, in this case, you cannot assume that age of majority is, in fact, one of the essential conditions. So if the question, if the question or option mentions any, thing regarding age of majority, that would be an extra assumption of knowledge that you are applying. So you have to stick specifically to the passage, and for that you need to read it very carefully. There's no need, there's no need of there's no point of skimming through the passage and then jumping to the question. Don't do that. Whatever, no matter how many times or how well you know the law on which the passage is based, it is always advisable that you read the passage carefully. There's no shortcut to it. Read the passage as carefully as possible, right? Then, while reading the passage, how do we identify? How do we, or what exactly do we need to focus on? See, when you see a passage which is about 300 or 350 words or maybe 400 words, there's a lot of clutter in the passage, right? Sometimes the name of the judgment, the name of the judges, that's all clutter. You don't have to focus on this information. Then what exactly you should focus on while reading the passage? It is those keywords that you have to catch, right? For example, there are conditional words which are used a lot in the legal reasoning passages. For example, provided that, unless, if, except. Once these words are used in between two conditions, then the first condition is not fulfilled without the second condition. So let's say if the passage says that Ram will not go out except if it rains. That means Ram will go out only when it rains. So these keywords you have to catch. Then there are contrasting words, which tells you the contrast or difference between two situations. For example, however, nevertheless, but, yet. Now, these type of words also are very important. So whenever you see these words, you have to underline it, you have to mark them, and you have to be very specific, very, very particular when you're reading to this, when you're reading these, when you're reading the passage, right? Then there are some words which tells you about the scope of the passage, or which I say as extreme words: every, all, none, right? Now, these kind of words, if you focus, these kind of words you have to be very clear about. It says that all X are Y. If the passage says all X are Y, then that means none of the Y is not X. There's no Y which is not X. So These words which tells you about the scope of a condition are also very important, and therefore you need to pay special attention to these words. Right? So overall, when you're reading the passage, be very attentive. There's no shortcuts. The approach where you just read the first and the last line of the paragraph of each and every paragraph and then jump to the question does not work in legal reasoning. There's no shortcut to it. Just read the passage in entirety, and that too very carefully. Ideally, you should, if the passage is of 400 words, you should not take more than 2 to 2.5 minutes. The ideal reading speed for Clat is about 150 to 200 words per minute. So if you have that if you have that reading speed, then it should not take you more than 2 to 2.5 minutes to read a passage. So don't hurry, don't rush through it. Read the passage carefully. That's the key. Now, moving on. Identifying the legal principle. Now, Sachin, there's no need to, understand the tone of the passage in legal reasoning. Sometimes, it's better that whenever the author is expressing the opinion. For example, let's say there's a passage on age of majority or age of consent in POCSO, or based on POCSO. And if, let's say, the author is criticizing the move of increasing the age of consent, then in that case, you should understand that what is the approach, or what is the stance of the author, what is the stance that the author is taking when he's discussing the passage, right? So in that case, you can understand the tone or the approach or the stance of the author, or maybe the stance of the court, but there's no need to specifically focus on understanding the tone of the passage, right? Next, identifying the underlying legal principle in the passage. So let's say the passage, if the passage talks about murder, and it also talks about the difference between murder, culpable homicide amounting to murder, and culpable homicide not amounting to murder. The very first thing that you need to focus on while reading the passage is understanding the difference, understanding the underlying legal principles discussed in the passage. Unless you understand it, it will be difficult for you to solve the questions based on that, right? So the whole passage will not talk about the legal principle. It will talk about some things here and there, but the underlying legal principle is what you need to focus on, because most of the questions will be centered around that legal principle, right? Okay, I have a question. The message comes to mind as good, but while asking question, the mind gets stuck. Then what to do? I can't get your questions clearly. I think what you're asking is whether or not, when the kind of answer that you get in the first reading, whether you should go with that or whether you should go with the second thought. I generally prefer going with the first thought. So let's say when I read for the question for the first time, I thought A is the answer, but then later on, maybe on a deeper thought, there's some other answer which comes to my mind. So I would prefer that you go ahead with the first choice, because usually the second choice you're getting is because of overthinking. You're thinking more than what is necessary, and therefore you should always go ahead with the first choice. Right? So understanding the underlying legal principle is important, but don't read too much into it. Don't stress it out. Don't read it again and again. There's no need of there's no necessity of reading the principle or the passage multiple times. Just give it a read, but only read it once, but read it thoroughly. There's no need of skimming through the passage and then jumping the question. Read it once, but read it carefully. All right. Next step is reading the question, and that too thoroughly, understanding the requirement of the question. And the most important thing is understanding the stem of the question. What exactly is the stem asking, right? What exactly is the stem asking? So let's say if the question gives you a factual hypothetical situation, right? Then after that, there has to be a stem of the question. After the facts, there will be a stem of the question. For example, decide whether A is guilty of murder or not. That is the stem of the question. Okay, what exactly do you need to find the question? What exactly you need to answer? Sometimes the stem could be what kind of inference you can draw from the passage, from the author's tone, right? What is the stance of the author regarding a particular legal principle discussed in the passage? So in that case, it is very important to focus on the stem of the question, and you have to read the question properly. And the next step is you read all the options. See, don't ever take shortcuts in legal reasoning. This is one of the most important sections. You don't have to take any shortcuts. Take as much time as as you need, but do not hurry. Do not rush through it. So please read all the questions. Sometimes you may find a better option. Let's say if you feel that option A is correct, but maybe option D would be a better option than option A. So it's always advisable that you read all the options. It's always advisable that you read all the options properly before marking your choice. Because legal reasoning is not about finding the right answer. See, understand the nature of the exam. They're giving you legal knowledge in about 300, 400 words. Now, they can't give you complete legal knowledge about a particular law in that. They'll give you half-baked legal knowledge. From that half-baked legal knowledge, you will try to understand and solve the question. Not necessarily you will get the correct answer always. Legally correct. Not necessarily you will get the legally correct answer always. So it's better that you read all the options and see which is the best possible answer. So in the legal reasoning section, the approach should be to find the best possible choice of the four options amongst the four options and not the correct answer. Sometimes there may be no correct answer in the options. In that case, you'll have to go ahead with the best possible answer. You'll have to go ahead with the best possible answer. All right. Now, next, what to do when you're stuck with the option? Because this is one of the, this is one of the question or one of the issues which most of you are facing. How do we eliminate? So most of you are able to eliminate two options. Let's say if the question is asking you whether A has committed the murder or not after giving you a factual matrix, you can you are able to conclude that A has committed murder. But what is the exact and there will always be two options which will say yes, he has committed murder. So now you're confused between those two options which says yes, A has committed murder. Then how do we eliminate that option? See, the best way to eliminate the option is to look at the red flags and the green flags. Now, most of the times, the red flag, the option which is incorrect, would have a wrong legal principle, right? For example, the passage talks about, the question talks about nuisance, and the question talks about nuisance, and the option is about negligence, right? So let's say the question asks you whether A is guilty or A should be held liable for nuisance or not, and option A says yes, he should be held liable for negligence. Now that's an incorrect answer. That's an incorrect option because it talks about an entirely different legal principle. These kind of options you should immediately eliminate. Then what are the other red flags, right? The options which assume a fact which is not mentioned in the question or which are based on an assumption which is not made in the question. Suppose the question does not mention that while causing the injury to A, B had the intention to cause death of cause death of A. But the option says yes, B is guilty of causing death of B is guilty of murder because he had the intention. Now, in this option, the option has assumed a fact which was not mentioned in the question. Now, that is another red flag. So these are some of the red flags you can actually identify in the option, and that will help you in eliminating those options. Then what are the green flag? The biggest green flag in the options is when you find that the language of the passage and the language of the option is somewhat similar, right? If the terms used in the passage are or in the terms used in the options are similar to the words that are used in the passage, then there are it is very likely that this particular option would be correct. So it is always advisable that if you're confused between two options, you go with the options which is closer to the passage, whose language is closer to the passage, especially if you're confused between two options. All right. Now, moving ahead. Okay, now this was a general intro of how do we deal with the legal reasoning section. Now, in the next part, in the next part of the of this of this session, we'll talk about how do we identify the difficult passage or what type of difficult passages are asked in CLAT and how do we deal with it. But before that, I'll take some questions from you guys. I already have one question. Sometimes question use our extra knowledge at that time we need to do the question or leave it because it is beyond the scope of the passage. Now, I always suggest the students that in case if you feel that the question is using extra knowledge or if the options are not clear or if you think that the question itself is wrong, it is always advisable that you attempt that question. Because even if that question gets cancelled later, you'll not lose anything. You'll not lose anything. So it's always advisable that in case if you think that the questions are beyond the scope of the passage or the options are incorrect or the question itself is incorrect, in such situations, it is always advisable that you attempt those questions. All right, any more questions from you? All right, so now let's quickly move to discussion on difficult type of passages, the kind of passages which might be difficult to deal with, right? Now, so through my analysis, through a deep analysis of the previous year paper, I have identified that whenever CLAT is asking a difficult passage, whenever the CLAT has to ask a difficult passage in legal reasoning, there are 4 variants of it, right? The first variant is one where the passage uses a very complex vocabulary, right? For example, words like estoppel, mens rea. Instead of specifically explaining the meaning of these terms, they'll use complex vocabulary. They'll use Latin maxims without an explanation of those terms. Now, such passages become difficult. Then, your worst nightmare are the passages which are based on unfamiliar topic. For example, something on insolvency law, and you don't know anything about insolvency law, or even if you know, you're not very comfortable with insolvency law because it's a complex law, right? It is not a basic law that we generally that you guys generally read when you are solving or when you are preparing for CLAT. Something on alternate dispute resolution mechanism, something very technical on ADR, something on patent law, international law. Now, these are the kind of areas which you do not prepare thoroughly. And most of the times you face it, you find it very difficult to deal with these passages. You find it very difficult to deal with these passages. Then the third type of passages which are actually difficult to deal with are the passages where the legal provisions are cited verbatim, right? So, for example, if the passage cites Article 143 verbatim, most of them, in fact, 90% of the aspirants will not be able to understand what is written in Article 143 unless they have prior knowledge to it, unless they know what exactly is mentioned in Article 143. It talks about the president's power to seek the advice of the Supreme Court in certain legal matters of public importance. But there are two cases in which the president can seek the advice. And both these cases are mentioned in Article 143, Clause 1 and Clause 2. On a bare reading of a layman would not be able to make a difference between these two conditions, or he or she may not be able to understand the meaning of Article 143. So whenever a legal provision is cited verbatim, the passage becomes slightly difficult to deal with. Then the fourth type of passages which may seem difficult for some of the students are passages which are lengthy, passages which are up to 450 words. Now, these type of passages in the last few years were very few, but the reason why they become difficult, why they seem difficult, is because they become overwhelming on the students. So you have to remember a lot of information while reading that passage. So it kind of becomes overwhelming on the students, and that's why a lot of you find it difficult to deal with, right? Now, these are the 4 different types of passages which students have generally found difficult to deal with, and I'll suggest you specific measures that you have to apply while dealing with such kind of passages. So now, in the next slide, I'll tell you about how do we deal with the passages which have a complex vocabulary. Then we'll talk about how do we deal with passages which are based on unfamiliar topics. Or what exactly are the tricks and tips that you need to keep in mind while dealing with such passages? All right. Now I'll ask. I'll keep it open for you to, if you have any question in mind regarding any other type of, or any other suggestion regarding any other type of passages that you find it difficult to deal with, and which you would want me to specifically address, and how do we deal with such passages? Because these are, on my analysis of the last 5 6 years of paper, these are the 4 types of passages which Clat has tried to ask difficult, which Clat has used to make the legal reasoning section slightly difficult. So whenever they have to give a difficult passages, they will use either one of these themes to make the passage seem more difficult than other passages. All right, you can put your suggestions in the chat box. The chat box is always open. All right, now let's try to decode the specific tricks and tips that you need to keep in mind while you're dealing with the passages with complex legal vocabulary. Now, one thing that you should understand, that the whole passage, the complete passage, will not have the complex vocabulary. Maybe one part of the passage will have words which you may not know the meaning of, or which you may find it difficult to understand. Right? Now, one suggestion is, rather than stressing out too much on that particular word, you try to understand the overall theme of the passages. Because what we have seen in the last few years in Clat exam is that questions will be based on the general understanding of the passage and not on the specific words which are difficult. So even if a word is difficult, there's no point of wasting time in stressing out on that word. It's better that you keep and have a general understanding of that understanding of the passage, and then go to the questions. Now, even if, let's say, a particular question is based, on that particular word, in that case, you may revisit that word. You may mark that word when you're reading the passage. You may try to revisit it. You may also try to understand the contextual meaning of that. You may also try to understand the contextual meaning of that word in the context of the question, and also in the context of the passage. And even after trying to understand the contextual meaning, if you're not able to find a suitable meaning of that word, there's no point of stressing out a lot on that word. You just move ahead. You try to solve the question, as many questions as you can. So that is a simple trick. Don't stress out too much on the particular words whose meaning you don't know. Right? Now, coming to the next type of passages, where legal passages are cited in verbatim. Right? Now, in these kind of passages, let's say if the passage is of 400 words and a legal provision of, let's say, 100 words, it's cited. Now, most of the times what we have seen is, whenever a legal provision is cited verbatim in a Clat passage, these kind of legal provisions will be accompanied by a very generic and very simple explanation of the legal provision. So if there's a legal provision, it will usually be accompanied by an explanation of the complex terms and terms which are mentioned in the passage. So it's better that you focus on that particular part, that particular explanation, and again try to have a general understanding of that passage, rather than stressing out too much on that particular legal provision. Also, what you can do is you can break down the legal provision into multiple parts and then try to understand it. Sometimes whenever the legal provision is quite lengthy, it becomes overwhelming, and it becomes difficult to understand. So when you try to break it down into multiple parts and then try to understand it, you may end up finding it very easy to understand. So when you're dealing with passages in which legal provisions are cited verbatim, it's better to break it down into multiple parts and then try to understand each and every phrase and then put it together, rather than wasting a lot of time and banging your head into that legal provision. Then how do we deal with the passages which are lengthy, which are more than 400 words long? The best way to do is break it down into multiple parts. Break it down. You break it down, let's say, into 3-4 parts, summarize it in the margins, maybe into one or two words. Let's say there's a 500 words passage, and The very first paragraph talks about murder. The second paragraph talks about culpable homicide not amounting to murder. In that case, what you can do is you can just summarize that passage in maybe paragraph in 1 or 2 words just on the margins. So that you will understand, okay, what exactly was there. So even if you have to revisit the passage or maybe some part of the passage, you will not end up wasting a lot of time in finding out the exact information that you need. If you have to deal with the questions which talks about if you have to deal with the question which talks about murder, and if you have already summarized that question in a paragraph in the margins, you will quickly go back to the information that you need without having without wasting a lot of time in understanding where exactly is the information in the passage that you need to solve the questions. So be focused, divide the lengthy passage into different paragraphs, divide it into multiple parts, summarize it, and then have an overall understanding. Right. Now, let's move on. Next is about time management. How you should manage time when you're dealing with the legal reasoning section, and how much time you should ideally spend. Now, if we look at the last 2 years paper, there has been 5 to 6 questions there were at least 5 to 6 questions in the legal reasoning section. 5 to 6 passages. Now, every passage, to read the passage, if it is of, let's say, 300 to 350 words, let's take the average, because some passages are 200 words long, some passages are 400 words long. So let's take an average of 300 words. At max, you should take 2 minutes to read the passage. 2 minutes to read the passage, and then maybe 40 to 50 seconds per question. 40 to 50 seconds per question. So that means you can solve about 6 questions in 4 minutes. About 6 questions in 4 minutes. So overall, not more than 6 minutes per passage. So if you're taking 6 minutes per passage, you'll end up solving the legal reasoning section in about 36 minutes, which is a good enough time, which is a very decent time. If you have spent 36 minutes and you end up scoring about 28 or 29 marks, then good enough. Then you are on point, your reading speed is on point, and your accuracy is also on point. You will do better than at least 95 or 96% of the candidates out there. You will outperform at least 96% of the candidates out there. And that's exactly the kind of competition that you need to beat in order to get into top 10 NLUs. Right? So please keep in mind 150 to 200 words per minute is the reading speed that you need to achieve in order to do well in the legal reasoning section or CLAT in general. Second thing that you need to keep in mind is that you have to avoid overthinking. A lot of time we keep reading the question again and again. Sometimes if when we're not getting the correct answer, when you're not able to, or when we're confused between two options, we kind of overthink and we kind of keep rereading those questions and options and passages, and in that process we lose a lot of time. Now it may not even be fruitful, or even if you, let's say, end up attempting that question correctly, still you will that will not be a very good return on investment. So if you have spent 3 minutes or maybe even 2.5 minutes in a legal reasoning question, even if you get it correct, that is not a very good return on investment, especially when we are talking about legal reasoning section. We need a very good return on investment in legal reasoning section. Less investments, more return in terms of score. So avoid overthinking, avoid reading the passage. Generally, the first option that you get in mind is the correct answer. Right? Third, building confidence is very important. This time is very crucial. You need to have a faith in your preparation, right? Because this is not the time where you can be worried, where you need to be worried about what will happen or how I'll do in CLAT, or I'm not scoring well in my mocks. See, I've seen a lot of dark horses running wild on the last day, right? When the D-Day comes, you get an energy. I've seen a lot of students getting a different kind of an energy. Their performance improves a lot under pressure. My teacher always used to say that Indians can do wonders under pressure. So maybe you have not seen that kind of pressure till now, and maybe the best performance is yet to come. So even if you're scoring, let's say, 60 or 70 odd marks in CLAT mocks, there's no way you should think that, okay, my game is already over, I'm already out of the competition. You can actually go on and perform better than those who are scoring 100 or maybe 105 in presently. You can outperform them. I've seen a lot of example where people have actually outperformed a lot of average students have outperformed students who are doing actually very well in the CLAT exam. So all that matters is those 2 hours. Be confident in your preparation, be confident about yourself, in your abilities, and you will end up doing well. All right. Now, the last part of the session, how should your 10-day plan should look like, or what you should do in the next 10 days to prepare for legal reasoning section. Now, I'm sure you all would have written at least 40 to 50 mocks uh, for CLAT. Now, one thing that you should do is you revise all the mock topics. There's no need of solving a lot of passages now. It's time that you gain a lot of knowledge. One of the most difficult kind of passages are those which are based on unfamiliar topics, on the topics which you're not familiar with. Now, in your mocks, in every mock, you will find at least 1 or 2 such passages which are based on unfamiliar topics. So if you have written 50 mocks, that means, and you have 2 passages which are based on unfamiliar topics, you'll have about 100 different topics to read. So my suggestion is you go through all the mocks, uh, list down the topics which you're not familiar with, read about them on Google, right? Read about those legal principles. So, for example, if you have a passage on the doctrine of res judicata and doctrine of res judicata. So, and if you're not familiar with this, just go on Google, quickly search about it, understand what is the meaning of the term res judicata is, and what does the doctrine says. So if you see a passage in CLAT exam based on res judicata, you are already familiarized with the passage, and then you can easily deal with that. Next, daily practice, at least 35 minutes. Do a time-bound practice. Pick up maybe 6 passages or 7 passages from any source, maybe from your worksheets or from your rank booster books or from any material that you have, maybe from the previous mocks that you've written. Make a set of about 6 to 7 passages. Try to solve it within 35 minutes. And at this time, it is very important, as I already said, it is very important to be confident in yourself, to be confident about your abilities, and have faith in yourself. That is more important. And also, solving the paper at the right time, or doing the hard work at the right time. We all know that our exam is going to be between 2 to 4, and that is one of the most unproductive part of our day. We usually feel lethargic during that part of the day. So it's better that we start preparing for it. It's better that we start preparing ourselves. It's better that we ensure that those 2 hours should be the most productive part of the day. So make your schedule in such a way that between 2 to 4 you are at the most productive level. So that also you have to ensure, because these are very small things, but they make a lot of difference. If you're not very active, if you're not at your best during those 2 hours, you may end up messing up with the paper. So it's always advisable, and in fact, it is mandatory that you have to be your absolute best. You have to be at your absolute best when you're writing the paper. All right. This was it from my side. Now I'll keep the floor open for the questions. If you have anything in mind, just you can write it down in the chat box and I'll answer. I'll wait for 2 minutes for your queries and questions. Okay, now this is a very common problem pointed out by Just Dream with Me. Okay, fantastic name. Okay, so a lot of time when you read, uh, let's say if there are 6, passages in the section and you've already solved 3, then you kind of start losing your efficiency. Yeah, your reading speed slows down, your effectiveness, your accuracy also, it decreases. Now, how do we deal with such kind of situations? Now, to deal with such situations, it is advisable that you plan your paper accordingly. So let's say there are three heavy reading sections in our paper: English, legal, and logic. Now, if you try to solve these three sections together, it is very natural that your efficiency of reading will go down. So it's better that you plan your sections accordingly. Maybe after doing the English section, you do one set of quant. Maybe do one set of quant so that you will get that essential break from reading. You'll get you because it when you keep doing the monotonous task of reading and reading and reading, your effectiveness and your efficiency goes down. So it's always advisable that you give yourself breaks from reading. And how to give yourself break? By utilizing your your paper, utilizing those quant sets, utilizing the legal logical reasoning puzzle if there is any, utilizing GK as a break from reading. These are small tricks and tips that can help you and that can keep motivated throughout the paper. So at this time, it is very important to finalize the sequence that you're going to follow in the mock. Now there are two types of candidates. One which always follow a definite sequence, which always follow a proper procedure, a proper sequence of the sections. Then there are some students like me. Whenever I am attempting the paper, I'll just go through the paper. I'll see how many passages are there, which section looks easy, which section look difficult, and then I'll go ahead and decide what should be my sequence. If I feel that GK is easy, I'll go and quickly finish off GK. If I feel that legal reasoning is easy, and I'll quickly jump to legal reasoning and then solve it. But ensure that you're not doing heavy reading sections together simultaneously. So if you have started with legal reasoning, it is advisable that before moving to English or logic, solve at least one set of quant questions. You will get that necessary break from reading, and that you will be re-energized to to deal with another heavy reading section. I hope it answers your query. All right. Any other questions, guys? I'll wait for 2 more minutes for the queries and questions. Sachin, I think the key to deal with analytical passages or the passages which have a lot of factual and statistical data, which is highly unlikely in legal reasoning section. But even if you find such type of passages, usually I would recommend that you avoid those, facts and statistics, because it is very highly unlikely that a question will be asked from that, right? Usually in legal reasoning section, they'll not ask question based on statistical or factual data. So it is usually, even if it is they've given in the passage, you would treat it as clutter and you pay much less attention to it than on other parts of the passage. So in a passage, focus on the legal part, focus on the legal principle rather than focusing on clutter like any statistical or factual information. But do underline it so that if there's a question asked based on that, you can always revisit that. So you must underline that portion so that you can always revisit that piece of information if required. All right, guys. As there are no more queries, let's end this session here. It was wonderful interacting with you guys. You had amazing questions. I hope you had some takeaways from this session. And in case you have any queries, you can drop your questions or queries in our comment box. We'll try to answer them as soon as possible. Thank you, guys. I wish you all the best for your exam. You hardly have about 10 or 12 days left for the final exam. Please take care of yourself. It's very important to take care of your health. Uh, Eat healthy, drink as much, keep yourself hydrated. Don't stress a lot. I know you guys have given a lot of efforts in your preparation. So be confident about your preparation, irrespective of how much you're scoring in mock. It is not the mock score, but the actual score that you get in CLAT that determines your selection, whether you're getting selected or not. So don't be disheartened. Don't look at how others are doing. Focus on yourself, focus on your preparation, and you'll all pass with flying colors. Thank you, guys. Thank you for joining the session. I'll see you again.